Ladies and gentlemen, thank you for taking the time to be with us today and welcome to the In-House Counsel Forum program and our first webinar in the series. My name is Nidhi Kilawala and I am a partner in Khaitan's Corporate and Commercial Practice Group. I would like to extend a very warm welcome to this webinar to every one of you, whether you are in our audience in India or around the world. The In-House Counsel Forum program is designed to provide training and education in legal operations, business, management, and substantive law relevant to general counsel and their in-house counsel teams, as well as provide a discussion forum on contemporary issues relevant to the in-house community in India today. Our subject today is AI governance, and on this slide is the agenda for today's webinar. In summary, we will have an expert panel discussion followed by a Q&A session with audience questions. We've already received several audience questions, but if you do have more questions, please feel free to submit them using the facility provided in the webinar portal. If we cannot cover all questions during the session today, we will make sure to reply to them offline post the webinar by email. Also, please note that a copy of the presentation, summary notes of the discussion, and a recording of this webinar will be sent to you as a matter of course after the webinar. AI is widely integrated into our daily life, often in ways people don't even realize. AI governance is therefore particularly important in today's world. AI systems can create legal, ethical, and reputational risks, including biases, privacy violations, and security threats. Proper governance would help to prevent these issues. Further, with increasing global AI regulations like the EU AI Act or the US executive order dealing with AI, organizations now need to be vigilant and also ensure compliance to avoid fines and legal challenges. During the course of our webinar today, our aim will be to discuss the key challenges associated with the use of AI, talk about how AI governance can help to mitigate risk and also provide some tangible takeaways and good governance measures that stakeholders should bear in mind as AI adoption grows to ensure that their organizations use AI responsibly and legally. Everyone who has registered for this webinar today should have received by email already a summary of the panel members and their credentials to talk on today's topic. So I will not spend much time introducing them. Suffice to say that they are all experts in this subject matter and qualified to express views on these issues. On our panel today, we are joined by our partners Tanu Banerjee and Supratim Chakrabarti. Thank you for being with us today and for helping all of us understand more about AI and the need for governance in AI today. So now let's start with our presentation. Members of the panel, over to you. Tanu, thank you for being with us and over to you.
Thanks, Nidhi, and a warm welcome to everyone, and thank you for tuning in today. In our first segment, I'll talk about what we mean by AI governance, why is it important, some typical challenges with use of AI tools today, how we can work through these by putting in place governance frameworks. And then I'll end the segment with just a flavor of what stakeholders, what is the role of stakeholders in terms of AI governance. And just to start off, what is AI governance? Now, AI governance refers to policies, regulations, or practices that serve as a guidance framework for development, deployment, and management of AI systems. Ideally, any AI governance framework should follow some fundamental principles. These are ethics and bias control to ensure that AI systems are designed ethically and with fairness. And in terms of deployment, AI systems designed in this way are given preference by enterprises. Accountability, which would mean that the governance framework should be able to establish accountability for decisions made by AI systems and determine who is to be held responsible for a certain AI-based outcome. Safety and security, which means that the mechanism for monitoring both development and use of AI should prioritize protecting privacy and security of data. Transparency, which would mean that the governance framework should emphasize AI systems to be explainable and understandable and make the underlying data sets and methodologies of an AI system accessible to its users. Human oversight, that is, having a framework which prescribes human oversight over use of AI, such that there is always a human in the loop before implementing a decision which is assisted by AI. And lastly, it's not possible to have an effective governance framework without a continuous monitoring system. This can help identify risks and also help find a resolution to these risks. We can move to the next slide. The next would be, what is the need for governance today? Why is it important? One of the first reasons would be to limit over reliance on AI. As we increase our adoption of AI tools, which of course has many advantages, a very high dependence of AI could also mean increase in the level of potential harm that it can cause. Excessive trust in technology without fully understanding its limitations can be a big challenge in the long run. And therefore, some mechanism is necessary for monitoring the level of use of AI tools, especially when it comes to decision making functions. Second is to mitigate ethical and social harms. Now, AI tools in their current form at least have many challenges. These can appear in the form of AI outcomes that are biased or discriminatory. We are all aware of potential job displacements. So, at a corporate level, we need to be conscious of these issues and have mechanisms in place to work around them. Third is to reduce bias. Since historical data itself is biased, using this data to train AI will only transfer the bias from humans to the machine. And while humans have the capability to factor in real circumstances, a machine may not have this capability. Now, an example of this could be, let's say a financial services entity uses an AI tool to decide on loan eligibility of different applicants. Historically, it's possible that a certain region of the country has more defaulters. And when AI tool is fed with this regional data, it's possible that its decision will be discriminatory simply because of the geographical association of an applicant. And there could be many similar examples. But having a governance framework can help identify biases in the AI outcome and put in place checks to reduce this. Fourth would be that a governance framework can help establish liability and accountability. AI systems involve various stakeholders such as developers, AI deployers, data providers, end users, and bodies, of course. Without a proper framework in place, it can be a challenge to make specific stakeholders accountable for specific issues. And this would then lead to increased disputes around use and deployment of AI as well. So, having an internal governance framework at the corporate level also helps assign responsibility within the organization and vis a vis deployers versus developers for AI assisted decisions. And lastly, an effective framework that takes into account ethics, accountability, safety, and has inherent checks and balances around these issues can ultimately promote a balance between growth of technology, innovation, while also keeping in mind safety of users. We can move to the next slide, please. Now, we're all broadly aware of the challenges with use of AI today. But what I want to talk about in this session is how these challenges can be mitigated through a governance system. The first bucket here is ethical concerns such as bias and discriminatory results, lack of transparency in terms of how a model is built, what is the quality of data used, or autonomous decision making without human intervention, without an explanation to how a certain decision or outcome is arrived at. Organizations deploying AI systems typically will have no control over the training data used by a developer. But what they can do is have internal systems to conduct tests before deployment and evaluate if the outcomes of an AI software are free from bias, are not inaccurate. Post deployment, an audit framework can help guide the way system audits can be conducted on an ongoing basis. And the concerns around decision making can be worked through by having internal protocols to prefer explainable AI models, for example, and to have a human in the loop before AI assisted decisions are implemented in any way. Then there are regulatory and legal risks. As such, AI is not entirely an unregulated space because we can depend on our existing legislation for basic governing principles, say privacy, confidentiality, IP, offenses, and corresponding punishments, etc. Yet there is a gap from a compliance and responsibility standpoint. So while we await a more robust regulatory regime around AI, internal frameworks can help address risks that are specific to different organizations. Stakeholders in the AI value chain can also liaise with different sectoral regulators and participate in policy making, especially in more sensitive sectors, for example, the financial services sector or healthcare and so on. We can move to the next slide, please. The next larger concern is data protection and security. Now, there are, of course, concerns around how training data is collected, stored, and then use of personal data. Once an AI tool is deployed, keeping sensitive data secure is also a challenge if consent protocols are not followed or restrictions on data transfers are not followed. Like in any digital tool today, AI systems are also vulnerable to cyber attacks, which can result in data breaches, plus inaccurate outcomes or outcomes that are manipulated by a third party. The only way to safeguard against this for organizations is to have robust data governance policies. That is, policies around minimizing inputs of sensitive data, anonymization, compliance with data protection laws, and enhancing cybersecurity measures internally. Then there is the global concern of labor displacement across sectors, corporate policies on investing in upskilling of employees or on redeployment of employees to newer roles, or even investing in awareness programs can be very helpful on this aspect. We can move to the next slide. Now, I spoke about the issue of over-dependence on AI at the beginning, and the resultant issue that AI-based decisions can often be incorrect. The only way we can work around this is by having internal mechanisms in place for monitoring the level of use of AI tools, retaining human oversight, especially for decision-making functions. And with regular monitoring and oversight, it's also possible to report an inaccurate result from time to time and taking corrective measures vis-a-vis the AI tool on an ongoing basis. And then the last one here, issues around IP infringement. Now, this needs to be looked at from the standpoint of AI generated output and the training data. For AI generated output, it's still unclear if the AI output is independently capable of copyright protection. And in terms of training data, there is an ongoing debate on whether a license is required for using existing copyright content to train AI tools, or if this can be exempted as fair use. Now, disputes on training data being used without a license have come up across the world. These could be minimized by developers by insisting on use of training data that is properly sourced, and or by deployers by maintaining human oversight on how AI generated output is used. And then, of course, one should have strong contractual protections against infringement claims and related losses. We can move to the next slide. Like I was talking about disputes on use of training data that are pending across jurisdictions. Now, in India as well, one of the biggest ongoing dispute on this issue is between ANI and OpenAI. OpenAI, which owns ChatGPT. ANI is an Indian news agency, and it has filed a suit against OpenAI. The dispute centers on claims that OpenAI has utilized ANI's published material, including publicly available content and subscriber exclusive content, without obtaining proper licenses from ANI. It is also claimed that ChatGPT has generated false narratives and attributed this to ANI's reporting. OpenAI, on the other hand, refutes that these allegations and says that the training data is used training data that is used comprises of publicly available information, which is exempt under fair use principles. Now, this is the largest AI dispute in India so far, and interestingly, our colleagues at Khaitan represent OpenAI on this dispute. We are all looking forward to the final outcome on this. We'll move to the next slide. Now, I also want to quickly touch upon the role that developers and enterprises can play in terms of governance. On the side of developers, first is model ownership, meaning that developers should take responsibility of their AI models in terms of data security, infringement, duplications, and so on. And to ensure this, it's essential to track progress of the algorithm regularly. Developers should also have a set clear internal guidelines and a framework covering aspects such as data quality, proper documentation, legal compliance. There should be standards around quality of training data that is being used. Now, this can be done by evaluating the training data for accuracy, bias, and source of the data. And once the model is developed, having an ongoing performance monitoring system is also crucial to make sure that the software is aligned with its original objectives. Next slide, please. And next, at the enterprise level, to start with, priority should be to adopt AI tools that are already compliant with existing laws. Then putting in place internal governance policies, for example, policies for ethical use of AI, risk management, policies around vendor engagement, forming ethics or risk assessment committees with experts. There could also be periodic training programs for employees, which generally promotes a culture of AI awareness. And lastly, revisiting operational contracts to make sure that they are robust enough to protect against AI-related risks. In our next segment, Supratim will do a deeper dive into internal policy frameworks and contractual protections that can be looked at. Next slide, please. Just some closing thoughts on this segment. Effective governance of AI is crucial to safeguard against risks of AI, and this requires a holistic approach that addresses concerns at various levels. Close monitoring of AI systems at the development stage, at the stage of deployment, and then periodically post deployment is very critical. And while AI is set to make our lives more efficient, there is really no substitute for human oversight, especially when it comes to decision making or decisions that are made using or with assistance of AI. And finally, we must recognize that tech advancements often outpace regulatory measures. And the more prepared we are to deal with issues around use of AI, the more effective our adoption of AI will be. With that, I'll close the first segment of our session today and hand over to Supratim. Over to you, Supratim.
Thank you, Tanu. A very good start and context setting, I would say. I will take this forward from here, and maybe the last slide that or the slide before that Tanu presented, I kind of start elaborating from there onward. So broadly, what I will cover are these. Okay, so firstly, a lot of in-house counsels are dumped with, say, AI tools and told to check legal compliance, etc. So we'll talk a little bit about that. We'll talk about governance policy preparations. Okay, what are the cardinal pillars? What should be kept in mind when you're drafting such a policy? Then comes the all-important governance committee. Okay, what should be the constituents? What they should be doing, etc. Next is building of AI culture. Okay, I remember I was, one of the very prominent speakers was speaking on culture and say it's not something that you pop today and tomorrow you will get culture. It has to be built over time. So we'll talk a little bit about building the culture for appropriate culture for AI and contracts. In a certain provisions we will go through as to how should you draft it, what are the nuances you definitely should keep in mind when you are drafting or reviewing contracts in the AI context. And finally, there was a lot of request to understand that, okay, which way is India headed as far as AI regulation is concerned? Are we going to regulate? Are we not going to regulate AI? Or should we take a middle of the road approach, etc.? So we'll talk a little bit towards the end of this presentation. With that, we can move to the next slide. So the first thing, like I mentioned, is this legally compliant AI tools, which is kind of thrust at times on in-house counsel. And what are the things that you should watch out for? First, of course, is the compliance with all applicable laws, and I think the list of applicable laws is kind of increasing. Okay, data protection, cybersecurity, intermediary liability, etc. Just to throw some more light on that, for example, the Data Protection Act, the upcoming DPDP Act of India till now did not talk about AI or emerging technologies, etc. But the recently released draft rules threw in a point which is very interesting to note, that significant data fiduciaries, which is like higher categories of data controllers, they would have to ensure that they do diligence on algorithmic software, and ensure that that is not impinging upon the data protection related rights that are there in the DPDP Act. Now, interestingly, that would mean you have to do a lot, okay? Because the set of rights that are there under the Act itself is quite a bit. Next, of course, is transparency. Make appropriate disclosure about AI accuracy, that it can make mistakes, and possibly the way to do it is a just-in-time pop-up where someone is about to use, say, a chatbot, etc., and they are pre-alerted that things can be incorrect and don't expect 100% accuracy at this juncture, etc. Otherwise, you could have situations like what we saw in the past, that a particular AI chatbot was bad mouthing the organization itself, and it was all over the social media. So we have to protect against such situations through various means, including a proper notification at the right time. And last, what Tanu was emphasizing on is the human oversight. There is no substitute for having a human oversight to override AI decisions when it is necessary. We can move to the next slide. So, right. So if you now we'll talk a little bit about the governance policy. And first, of course, we need to have an accountability framework. Okay. And for this, probably you can think of an AI compliance playbook. We have observed that most of our clients have benefited quite a bit from having such a playbook. And it is like a reference point for employees to ensure data integrity, security, etc., whilst they're also ensuring that they are minimizing legal and operational risks. Okay. But what we try to do is that it is not only know how, it's also show how, right? It's not only left in that particular book of policy, it is translated further into telling people more specifically in the context of their working as to how this can be relevant for you. Simple example could be, if you are a HR person, from hiring to firing, a lot of tools are being used which has got AI. Now I have to talk in your language to make you understand that where things can go wrong, what are the specifics that you need to maybe watch out for. So it's not one person's baby, it's everyone has to come together and play their respective roles. So this kind of playbook kind of helps. What are the cardinal pillars when you think of a policy that you should be aware of? First, of course, is data governance. It's the oil, or it's basically something that will fuel everything, right from the first stage to the last stage of AI's development deployment cycle. You'll see data plays an important role. So you have to ensure that the policy talks very clearly about data collection, storage, processing, ensuring that all applicable laws are kind of factored in, including any cross-border laws that you need to be mindful of. Next is the risk assessment. You have to have the AI model to undergo validation, stress testing, red teaming. Just for the understanding of this particular audience, it will be like creating a fake attack to check that whether it is good enough to withstand any kind of an attack of that sort. Next is you have to have fairness testing. Okay, implement the guidelines to prevent bias or discrimination. And this is not a one-time process. This has to continuously happen. We have had situations where when the client has deployed an AI tool for the first time, maybe initially it has worked out well, but later on there were problems or issues which were observed, and therefore this continuous process really helps. Next is incident response. There could be concerns or issues or incidents which can happen. You need to establish a strict reporting mechanism for any AI related incident. What we are observing right now is in India, um, in the cyber incident context, if there's something which is to do with AI, regulators have become more touchy and asking more pointed questions. So we need to be better prepared. We can move to the next slide, please. Right. So let's talk a little bit about governance committees and the risk assessment. We have tried to break it down into three bite-sized pieces. Firstly, the structure of such a committee. Again, people get a little lost that you will have IT and legal. Again, like I mentioned, it's not one person's baby. So it's like legal, compliance, IT, risk, business. You should have uh, all relevant stakeholders, and there should be responsibilities cast on each of them. What will also happen through this is you will get a more well-rounded set of inputs and can then consolidate the views pertaining to a problem statement that you're looking at. Okay. You can also think of appointing an AI risk officer or a responsible AI lead. And you definitely need to report whatever are the findings, conclusions, etc., drawn to the board of the company or the senior executive committee, whatever is the structure of your organization. Next is what should be the functions of such a committee, right? So I think firstly, of course, define the AI risk policy properly and ethical guidelines to be followed, monitor and evaluate the use cases on AI deployment, especially the high risk ones, where you know that things could be more damaging for the organization in case there is any issue. Review and update AI policies on a regular basis. Like I mentioned, laws are evolving, technology is evolving, and laws are evolving across the globe. So depending on what all is applicable to you, you need to constantly recalibrate. Okay. Sometimes you'll have to do marriages of several laws, like I was mentioning, the Information Technology Act, the data related laws, new aspects which are coming from sector regulators in the context of AI, etc. Next is accountability. Okay, what you need to do is implement a process for regular model audits and continuous performance monitoring. Define the protocols that are relevant, and also have a whistleblower mechanism. If something goes wrong, there should be a avenue available to the relevant stakeholders to raise a concern or an alarm. Okay, and it could be internal and external. So we can move to the next slide. Great. This is what I was talking about when I started off about AI culture, right? Training, sensitization, workshop. See, there is no two way about it that training is super critical for any organization, especially in this evolving space of AI. What we have started doing now is created 2 to 3 different kinds of training, sensitization, and workshop modules. Okay. For example, the top management will not have time for of all the nitty-gritties to be heard, right? So we do a slate 45 minutes to 1 hour session for them to explain the evolving situation, what are critical for the organization, how the governance would be carried out in the organization over a span of time to take a buy-in. Okay, they might need to sign off on certain people, double hatting, triple hatting on all of those, right? So that is the objective. The next one would be the mid management who will oversee the governance program, and then you have what we've started calling as AI champions. Just like you have privacy champions in your different business functions, you need to ensure that they are properly trained, and they are trained through simulation exercises, pointed questions pertaining to their area of work, etc. There is hands-on experience given of, say, to report an incident. Okay. Things like those. So all of these we are doing right now, and this has been a successful model that we are observing as far as awareness, training, sensitization, and workshop is concerned. What you need to do is, again, AI is not just an IT issue. You need to get out of that mindset and ensure that you have people from every function, legal, HR, risk, business. It is also interdisciplinary, kind of nature, and therefore you need to have talk about the compliance challenges, ethical dilemmas, and legal obligations with all your folks, and also encourage your employees to engage and give feedback on a real-time basis. Okay, that's how you can have a successful program. uh, Try and have more case studies. There's not too much of case law right now, but case studies we have seen have worked wonders. We can move to the next slide, please. Right. So this now we'll talk a little bit about contractual provisions, which is super critical for in-house counsels. This is just a snapshot. There are various permutations, combinations, and other things that may have to be thought of. But we thought that these are kind of the cardinal ones which we must sort of bring out. One is, of course, require the vendor to be compliant with all applicable laws in a vendor's and service recipient scenario. And this includes the laws that I talked about. Inter alia, you should include all of those. Define who would be responsible for AI errors, biases, and security breaches or regulatory violations. What we have observed at times is there is not too much of a discussion which happens, and therefore things are drafted very in a broad brushed manner, and you happen to take on more responsibility than you should have taken on. We have seen instances where the coffee vending machine of the organization and an AI tool has been bought with the same template. So this is really disastrous. Ensure that you spend adequate time in understanding what is being procured, the deployment that will take place, and who should be responsible for which part of the problem. Okay, delineate and kind of played this out quite in detail, I would say. Next is ensure that liability extends to the AI system malfunctions and bias related harms, data breaches. This could be a very little complex debate or discussion at times, but it is better that you do it because we have seen situations where an organization has promised to its customers that everything is kosher and will fully cover you for any liability. And at the back end, if they have procured the tools from someone, that particular arrangement has a lot of restrictions and caps as far as say responsibility, liability, indemnity covers, etc. is concerned. So you need to understand the whole chain properly. Next is require the vendor to undergo AI impact assessment and risk assessments, which is becoming, I think, the norm right now. Um, Standard liability caps, like I was mentioning, under contracts will not really be helpful here. You'll have to be creative about it. In short, if I have to give you one statement to remember that you need to have trusted partners around you. You drafting something alone may not help. You'll have to do better due diligence. You will have to see that what you are writing in the contract, that particular counterparty is actually able to stand behind that and also backstop it more creatively. Not only maybe indemnity. Do you need a bank guarantee? Do you need a holdback of sorts? Is there an escrow required, etc., etc.? Think through depending on the criticality of the arrangement. And finally, indemnification insulation for regulatory fines, reputational harms, etc. Regulatory fines in India is also skyrocketing. You have already seen under the data law, it is rupees 250 crore or more, depending on what happens. It could be a similar construct for future laws, which would be crafted in relation to AI and emerging technologies in the country. We can move to the next slide, please. And now I think we'll move on to some of the clauses. We can move to the next slide and start. And these are just some examples. There are various ways of crafting, but just so that you get a flavor, this sample indemnity clause is from the service recipient side. So here, if you see the AI service provider is promising that it will defend and hold harmless and indemnify the recipient in relation to any claims pertaining to intellectual property, and you can go ahead and kind of further delineate the kind of intellectual property infringement that would be there. Also, you should ensure that aspects of data protection, privacy, unauthorized access or use, disclosure of personal data, as well as errors, omissions, or failures in the performance of AI services are covered. We can move to the next slide. The next sample is from the other side. So it is from the service provider side. And if you look at this particular clause, the recipient is saying that it will indemnify the provider from the recipient's misuse, okay, alteration or unauthorized use of any AI services. You need to ensure that uh, there is no violation of applicable laws or regulations, including data protection, privacy, intellectual property, and other third-party related claims related to the recipient's business. You should not be taking the responsibility of a recipient's business practice or actions which are based on AI generated outputs. Okay, this is something which should be ideally beyond the remit unless it has been specifically negotiated under the business arrangement. We can move to the next slide. The next slide actually talks about three other critical issues which we have observed an in-house counsel grappling with when contractual provisions are getting vetted or drafted. First one is for AI service recipient to protect against infringement claims. So you need to ensure that you provide something like this, which is saying that the provider has trained AI using third-party intellectual property in compliance with all applicable privacy data protection laws, and also sought relevant licenses and permissions that are relevant. The second clause that you see in the center is AI service recipient, which needs to ensure that data is not used for training data. So while we are giving you the data, please ensure that this does not get into your pool of training data. And maybe you can craft it in this manner, which is in the center. The recipient data shall be used only in the manner specifically authorized, and it is restricted, including restricted from being used for training. The last one that you see here is where the user is granting access for training purposes, the training of that model maybe, but there are certain other restrictions that the person wants to put, and that is this data should not be used for commercial purposes or used in a manner that infringes third-party intellectual property rights or violates any applicable law, or it is sold or loaned, etc., modified, translated, adapted, and adversely impacts the business of the user itself. So that you need to protect against. We can now move to the final slide where I will recapitulate what I talked about till now. Okay, so before that, I think we'll talk about what is India's journey and which way are we headed. As a quick snapshot, again, we are aware that firstly, Information Technology Act and IT rules and the intermediary rules have been handy quite a number of times for fixing several issues. So when we had this issue of an actress's deep fake coming up, there was an attempt made to kind of fix it through these rules, and there was an advisory which was issued, you would remember. Amongst other things, the advisory talked about appropriate labeling of under-tested and unreliable AI. It is very surprising that in today's world, we don't know which AI would not fall in that category. And probably everything has to be kind of mentioned as under-tested and unreliable. So one tip could be that please ensure that the notice that you're providing to the users, you kind of clearly call out what could be the pitfalls, what could be the errors that could occur. There are several other things in that advisory. Next came Digital Data Protection Act, the DPDP Act. Of course, I told you what we saw recently in the draft rules as far as AI is concerned. And then we wanted to talk a little bit about Digital India Act, which has been in the making for quite some time. It is supposed to be the mother umbrella legislation for technology in India. Let's see in what avatar and when it will come out, but that also intended to regulate emerging technology, AI, and under the larger umbrella of emerging technologies. Interestingly, it also attempted to unbundle the concept of intermediary. Okay, today when you see the definition of intermediary under the Information Technology Act, it starts from internet service providers and goes up to cyber cafe. If you're trying to regulate the ecosystem with this kind of a broad brushed approach, it might not be fruitful given the time that we are in. And the attempt that was at least tried to be made through this Digital India Act was that we will unbundle it. Different categories of players should have different categories of compliances to look at. But let's see what happens to that. Next is MeitY's recent report on AI governance guidelines. It kind of gives a drift of a principle-based approach of lawmaking, and certain baseline categories could be given to commercial players, and above that they could determine what are the other good to haves that they can add on and responsibly work on AI. In the meantime, like it happened with the data laws as well, the sector regulators have gotten fairly active, and whether it is the securities regulator, SEBI, or the Reserve Bank of India, which is regulating banking and finance sector, they have started talking about AI. Some of it is in a very pointed and a comprehensive manner. So with that, I will move to my last slide, and this basically recapitulating what I talked about. Minus, of course, the India's regulatory journeys. Firstly, of course, establish robust governance policies. We talked about the pillars that you should keep in mind when you're drafting such a policy or maybe reviewing it. Establish risk committee for oversight, how to frame it, what should be the responsibilities of such a committee. We talked about all of those. And finally, of course, review, negotiate contractual provision with the lens that we have kind of provided to you. There's much more to talk about, but that's all for now from my side, and over to you, Nidhi.
Thank you for that, Supratim and Tanu. I thought that was immensely helpful and very insightful. I hope the audience enjoyed it as much as I did. And before any further ado, I think I should go straight into the audience questions that we have been receiving. Um, Maybe my first question can be to you, Tanu. We spoke a lot about how regulation in an AI context is still evolving, and India doesn't have one sort of mother legislation which encompasses all aspects related to AI governance. So, just in light of that, the question we have here is, given that laws are constantly evolving, how frequently should AI models that say our audience is using be audited for legal and ethical compliance?
Thanks, Nidhi, and very interesting question, in fact, and I fully agree that there's some runway still left before we have really like a robust regime which addresses sectoral issues. So before we get to that place, of course, audits and monitoring are crucial. Um, when these should be done and what intervals these should be done, I would say as many as possible and as frequently as possible, perhaps, but that's not a practical approach to it. I think that just some milestones that should definitely be thought through are one, uh, before we decide adoption of a tool or we zero down on a particular tool that needs to be deployed. So pre-deployment, a proper audit monitoring exercise can be done. This can be done maybe through an external party or an auditor as well who has that expertise to do this sort of audit. Then is at the time of deployment, and that testing and audit may be with different aspects in mind. One is to ensure that it's compliant and other sort of facets and broader issues that we've spoken about around bias and ethics and so on. But also that testing is important to see how that tool is being integrated into your existing infrastructure and systems, right? So that sort of audit and review is necessary at the time of deployment. And then following from that, I think it just depends on what is the scale and scope of the specific AI tool in terms of what intervals are necessary. It could be biannual, quarterly, monthly. But that is something that every organization will have to take a call on in terms of post deployment. It could depend on multiple things. It will depend on the function that that AI tool is sort of playing. It will depend on whether you can have internal teams who are capable enough to do these regular audits. And if not, there could be some sort of balance between internal teams and a third party vendor to do it from time to time. So post deployment, I would think it's a organizational call, but um, as frequently as practically possible.
Sorry, if I may just add, Nidhi,
Yes,
one
please.
one point here. I think one aspect which could be very helpful here is a risk or a harm-based principle to be followed.
Hmm.
And whenever there is any possibility that you perceive that there could be risk or harm sort of caused, then you may consider to do it a little more frequently than maybe a set benchmark which you will already have, say, whatever, yearly or half yearly. But if in the interim you believe that there could be risk caused or harm caused, then possibly you can fast pace it
Yeah,
and do it at much.
absolutely.
Got it. Very helpful. Sounds to me like important to be proactive than reactive with a lot of these evaluations with AI tools as we increase adoption and look at how laws are sort of impacting the use of AI. Thank you for that. Very helpful. The next question, maybe Supratim, I'll bring you in on this, and would be good to get your thoughts. Um, Interestingly, the question is around global regulations and how operating in India, but maybe having access to information, say world over, how does that sort of tie in from the perspective of, say, an organization that operates internationally, and what global regulations, especially in an AI context, should organizations then be mindful of, given their international presence or operations?
Right, I think great question and very timely, I would say, because we are observing almost every jurisdiction is now in the race of drafting some law or the other. We have heard a lot about the EU AI Act and how they have taken a risk-based approach, okay, which I was kind of alluding to also, which is different categories of risk being identified and regulated as per the risk. And we have seen in the past that this has had a Brussels effect, right? They create some law and then it is emulated or taken inspiration from, and other law countries will all kind of also prepare laws accordingly. Interestingly, what we are also observing is different jurisdictions are taking different approaches to regulating AI. Okay, you could have some who are taking an outcome based approach. Okay, like what comes out finally, let's kind of regulate that. Then you have this risk based approach. There are several others. Now, being in India, I think many times people ask this question: Are we late? Are we late in the race to draft some principal legislation on this at the end? Maybe we are late by design. The reason is in the past we've seen some, so just as an example, the data law, we were late, but we could see the mistakes that other had made. And we did tried at least not to make a similar mistake. India is at a very delicate stage, right? Whilst it is important to create all these comprehensive laws, but you have to remember that innovation, entrepreneurship, ease of doing business, that should not suffer. That has also been a balancing act which the government has tried to at least showcase and tell. And if they have to really put that into effect, then you cannot suddenly clamp down and bring in a very strict law, which could be problematic. But when you're dealing with multiple jurisdictions, A, of course, try and follow strictest of the lot, okay, which will be helpful. In a bad day, it will help you because uh, then you need not really follow, okay, every fluctuation that is taking place in every jurisdiction, you are looking and trying to attain to it. So try and somewhere have a benchmark which is strictest of the lot. And the other thing is, there are certain insulations which could be available in some cases. Okay, we have to see whether such insulations are available to use. Just to give some simple examples, publicly available data. In many jurisdictions, when you crunch that data, that is outside the purview of the data protection laws, etc. Right? There are some jurisdictions which are giving you exemption for research, analytics purposes, etc. So, are we able to utilize that avenue? Things like those. So, long-winded answer, but I think that's where we see ourselves today. We will have to create a defensible strategy. Mind you, that's not following any particular law. It's like a defensible strategy which is trying to take the global gold standards from the world and see that at least we have that. So if a question is asked, I can defend myself, my organization.
No, super helpful. But then, if I were to just take that and say apply it in an Indian laws context, right, and try to see what's happening with, say, the IT Act or the DPDP Act, how do you look at Indian laws like that impacting AI deployment in the Indian context? And is it very
So,
different from everything we just spoke about, from an international standpoint?
I think till now, what we have seen is that India has taken a bit of a knee-jerk reaction, or when situations have arisen, they've talked about, okay, we will regulate it in this fashion. When you talk about the Information Technology Act, um, like I mentioned, that the intermediary rules are there. The attempt was that can be regulated through the IT intermediary rules. Now there is a bit of a legal glitch there. The glitch is like this: when you think of an intermediary, it is basically supposed to be a dumb pipeline or a dumb container. You are the postman, you don't know what package you are carrying, and therefore you should be insulated, okay, unless you are carrying something illegal and things like those. So what happened over time is there was a lot of responsibility given to this intermediary, and we have now reached a time where you are almost looking into the data to see that whether it is something illegal or not, right? So we are in a very tricky zone. Now, in an AI context, you are not always an intermediary. The definition I try to simplify, right? You're not originating the data, you are not changing the data whilst it is in course, you are not selecting the end recipient. In a classic AI scenario, you may not satisfy all these parameters. And therefore, if I say that I will regulate AI through only the intermediary rules, it may not be foolproof. Okay, so definitely we needed to do more, and therefore we thought of having umbrella legislation like Digital India Act, when if and when it sees the light of the day, where things would be more classified. Like you slice and dice, you create different kinds of players, different intermediaries maybe, and give them different responsibilities. That will be a better way of regulating AI or emerging technologies, I would say.
And Nidhi, just to add to what Supratim is saying, I think in the Indian context and some of the other jurisdictions have also sort of followed this approach. Singapore, for example, right, where there is still perhaps some way before or some time before a mother sort of consolidated legislation comes about, but there are sectoral guidelines, right, by different sector regulators. So that's what is happening in India as well, right? SEBI came out with something, MeitY has come out with something, RBI has come out with some sort of, guidance framework that they're thinking about. So, and just given the demographic that we function in, the number of people, the number of different kind of businesses, entrepreneurs, etc., I feel that we are on the right track in that sense to define sectoral compliances and guidelines, because every sector has its unique issues and challenges also, right? So just having one sort of legislation which fits everybody, exactly like Supratim is saying, you may not always be an intermediary if you are using or deploying a AI tool. So you will have to analyze the legislative regulatory framework depending on where you're operating. And for that, I think the sector regulators are best placed to come up with some framework.
Nidhi, what I believe is the way the direction that we are taking is exactly the direction that our data laws took. It took some time for the mother legislation to come in. In the meantime, sector regulators could not stop themselves because it was directly impacting them, and they were more closer to the issues that people were facing. And they talked a lot about things to be done by the players that they were regulating, and then the mother legislation came in, which is giving an overarching principle. And they're trying to say that, listen, per se, that we are not expecting that there will be a conflict. You try and see and that you fit in under this umbrella legislation that we have created. Possibly, this is the same drift that we will observe in the AI regulation. Sector regulators will start talking and have started talking about things, and they will codify certain things for the players that they are regulating, and then you will see an overarching principle-based legislation coming out in this regard.
Yeah. So super, super interesting. Thank you for chiming in with both your thoughts, Supratim and Tanu. I think it's a good segue into the next question that we have, which is, and maybe Tanu, maybe you could get started, and Supratim, you can chime in if needed. How do you think, Tanu, liability should be allocated between developers, vendors, and say eventual users of AI systems, especially given the context the two of you have been discussing right now, that in an AI world, it's probably a bit more, the waters are muddied as compared to say a typical sort of IT tool. And
Yeah.
so how would you look at that from a liability allocation perspective?
So again, one is that, any of this assessment, who's responsible, who's accountable, what policies should be in place, so on. One of the fundamental things is that all of this is sort of dependent on what is the role and the functionality of that tool also. And those stakeholders amongst developers, vendors, users, what is the function that each of these are sort of playing, right? So, for instance, I think developers could be made liable and accountable for the design, for functionality, for let's say testing of the tool, right? So those sort of things at the origination level is something that a developer can be more responsible for. Now, if you have a vendor in the value chain who is sort of responsible for distributing or selling or scaling up the sales of an AI tool or deployment of an AI tool, then there the liability could be more in terms of integration issues or model training or again, some amount of testing. Let's say support for backend on an ongoing basis, updates for the tool malfunction. So those are perhaps something that you could, identify the vendor to be responsible. And then at the user's end, I would think largely the liability and accountability would be towards misuse of the tool. Right? So these are just broader buckets. But of course, all of this needs to be sort of evaluated in terms of what is your underlying arrangement, what tool are you deploying, what is the scale at which you are deploying it in an organization, right? Something could be very small, right? And not have as much risk associated with it. Or there could be a tool which is really rolled out at a larger level. It is integrated for a critical business operation, business and revenues and operations, and maybe customers, users are somewhat interfacing with that tool. So there are various dynamics in terms of doing this, but maybe just what I touched upon are the broader sort of ways to look at it.
Thank you for that. And while we have more questions, I'm just keeping one eye on the clock. And like I said, we'll reply to those offline after the webinar. Um, Thank you, Tanu and Supratim. It has certainly been a thought-provoking event. To me, honestly, some of the key takeaways were much like the time we spent on this webinar. Um, few minutes were spent on whether AI governance is required, but more time was spent on what needs to be done. So I think and that's reflective of what's happening in the market. Everyone is mostly aligned, including key stakeholders, policymakers, that AI governance is required. The question really now is what should that governance be and what it needs to look like. And so thank you for spending time at least to give our audience a little peep into what we're seeing in the market, because effective governance is crucial for risk mitigation when using these AI tools. Monitoring of these AI systems is important to stay ahead of these risks, as both of you have adequately pointed out. And there are many ways in which this can be done. There is no one size fits all sort of response to that question. But what we have seen work well in the recent past are things like setting up a governance committee, which includes representatives from different sort of limbs or verticals of the organization, creating a lot of awareness within the organization while using those tools, doing regular audits. Before deploying the tools, then at the time of, and then going forward as well. So depending on really what is the tool that you're looking at, the governance mechanism could vary. And thank you again for shedding light on that. And lastly, I think I will end with, and to borrow what Tanu in fact said, is that human oversight is needed when using AI. And so it's not like a total replacement for all the supervisory sort of mechanisms we would otherwise put in place. And so it's important to bear that in mind as well as to when that human oversight needs to come in, especially for some of the more crucial sort of decision-making aspects. So thank you so much once again. And thank you to our audience as well for joining us here today for this riveting topic and discussion. Before closing, I would like to request each of you to please respond to the poll slide that will be on your screen now. We take this very seriously as part of our continuous improvement program. So please do provide any feedback that you have based on the session today. Thanks to everyone who also participated in the poll. Finally, I would also like to thank all our panel members here for sharing their expertise and experience with us today. You were simply outstanding, if I may say so myself. Thank you so much again. And also thanks to you, our audience, for your attention and your questions. I think this was a very interactive Q&A session. So thank you for being such an engaging audience. I hope you found the webinar to be an interesting and a worthwhile investment of your time. We certainly enjoyed bringing it to you. After the webinar, like I initially mentioned, we will be sending you a copy of today's presentation materials, summary notes, and a link to the webinar recording. You will also separately receive a slightly more detailed request for your feedback on the webinar, more detailed than the poll you just took right now. Please do take the time to send us your feedback, compliments, criticism, comments. Everything is welcome. The form will take less than 1 minute, hopefully, to complete. So we'll be really grateful for your time on that. And if you are interested in in-house training or any other matters arising from this webinar, please do not hesitate to contact us. Our contact information is on the contact slide here on your screen. Thank you for your attendance today, and we look forward to being with you again at the In-House Council Forum.
Thank you.
Thanks everyone.